Whether it's traffic stops, possessions of drugs, or privacy in your own home, the Fourth Amendment protects you against unreasonable searches and seizures. Today we're going to break this down, talk through some hypotheticals, and tell you what your rights really are under the Fourth Amendment. Welcome back to Hashtag Lord, you guys. We got the A-team here again.
Hey.
And diving in, we've been a little criminal heavy here lately, but
we
I
hear
love
you
talking
guys
about
like
it.
criminal law.
Well, it goes with all the, we were just talking about it right before the show.
Yeah.
I mean, all the True Detective, Criminal Minds, all the Netflix true crime documentaries. Everybody loves that stuff.
I know, I saw this little Instagram reel and I was like, oh, I feel seen. It was this guy and he was mimicking his wife, right? So when he like pretends to be his wife's scared, he puts a towel over his head, to show that she's got long hair. And it'll be like, oh, anytime she sees a cheesy Halloween horror movie, oh, too scary. But then, in order to relax, she's sitting there calmly eating her cereal, watching a murder mystery where someone her age is brutally murdered and dismembered. And she says, how relaxing to watch this documentary.
Right. That's pretty perfect. And I've made jokes like that plenty of times before, because it is crazy how people have gotten really obsessed with those types of documentaries.
Well, I've got a theory as to why especially young women are obsessed with these documentaries and these podcasts.
Yeah.
It might sound irrational to you, but I actually think there's a rational basis for this. The more I know about how these horrifying activities take place and how these criminals think and how they trick the women to fall into these traps to then, brutally murder and dismember them, the better prepared I am to avoid these situations. And now my inner alarm bell is more finely tuned. So for example, I listened to an episode of My Favorite Murder, and this one woman called in and she said, I looked around, I saw this guy, he was in the parking lot, and I was like, I'm getting a weird vibe. And he was slowly walking towards my car. And I was like, that's strange. Am I overreacting? Looks around, she's like, F being polite, I'm getting to my car right now. Runs to her car, throws herself in, locks the doors, texts her husband, probably not the best move because time is of the essence.
Yeah, driven off there.
And then she jerks the car forward. The car clearly hits something, bumps, and then her first thought is, I should get out. And her second thought right after that is, no, what if he put something in my car to try and get me to get out? And then he's going to knock me unconscious and then kidnap me and dismember me. So she hauls booty out of there and she looks around. The guy had put, I think it was some sort of like rock or brick in front of her front right passenger wheel. And he was looking up and he looked shocked that she hadn't stopped and gotten out of the car. So that guy clearly was trying to get her to get out of the car. And so because she listened to her instincts, which is, I've seen or I've heard people do these crazy things, and maybe I'm not being crazy, I need self-preservation, F being polite, I'm going to get out of here. She avoided possibly being kidnapped, murdered, and brutally dismembered.
So you're saying it makes you more self-aware?
Yes.
This is your long version of
yes.
Okay, good.
Yeah.
Good.
Spencer says I don't have enough situational awareness, so I'm working on that.
Well, hey, you know what? If that is going to make you feel more aware, make you more vigilant, then I'm totally fine with that.
Okay.
But today we're going to dive into the Fourth Amendment, and the Fourth Amendment. I think we've talked about this before pre-show. Sometimes it's a little misconstrued, and not everybody understands exactly what it means.
Yeah.
And so we're going to break it down and try to hit on some big concepts. It's the hundreds of years of litigation and Supreme Court precedent that have tailored the Fourth Amendment. We can't go into all those nuances, but some big picture issues and some big picture concepts. There's things that we can talk about.
And
today.
how recent, too, a lot of the concept of unreasonable search and seizure is.
Right. Well, and it's also, and there's a part we're going to talk about in here, but it's the Fourth Amendment is ever evolving because we get more technology, we get more, certain things happen in society that the expectation of privacy gets larger, all those types of things. And so, of course, now I'm going to tell this story. In 2015, I was at a criminal defense seminar here in Texas, and in 2014, there was a case that came out from the U.S. Supreme Court. And typically, if you arrest somebody, you can search them incident to an arrest, meaning, after you cuff them.
Search their person.
Search their person. You don't need a warrant for that. Well, Supreme Court came out and said you can't go through somebody's smartphone just because you arrested them, because that's like a computer that you've got sitting right there. And so you have to actually go and get a warrant. And so my girlfriend makes fun of me for this, but, well, gotta get this off of here.
Yeah, I was about to say, don't show the text.
But so on my phone, if I ever get arrested,
hopefully not,
I at least let them know they got to get a warrant to search this phone.
Are you going to ask me to bail you out if you get arrested?
I don't know. That might strain this relationship. I might start getting judged on the show a little bit more if that happens.
I judge you already. It's fine.
That's a good point. That's a good point. Well, like we always do on the show, we want to go to the actual text of the law. And so I'll just read the Fourth Amendment here on air. It's the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Obviously, Bill of Rights, written back in 1780s.
Back in the day.
And I won't delve on this too much, but I do think it's interesting. We got to talk about where this came from.
The background.
Yeah, so it came
Context.
from...
Context is king.
I mean, we all know that the reason that we became independent from England was because we were being oppressed in a lot of different ways. And
religious, politically.
Taxation, all those types of things. And this was one of these specific areas that had most of the colonists outraged. There was these things called writs of assistance that the Crown used during pre-revolutionary time, where British soldiers and officials could arbitrarily search homes, private property, typically looking for goods that were illegally imported. People did that to avoid the taxation. Right, exactly. And so they'd come into homes, they'd search around, and they'd find other stuff. And I'm sure, I mean, in my mind, I'm just going to think that they corruptly probably took food and other things while they were in there.
I'm sure they probably took food, or maybe they were like, oh, this shawl looks nice. I'm going to get this for my lady friend.
Right.
You know, and it belongs to someone's daughter.
Right.
Pigs.
Yeah, and of course, colonists were pissed off about this.
I would be too.
And I actually didn't know this part until I did this research, but James Otis, who's a Massachusetts lawyer.
What a name.
I agree. He had been described as the founding father of the Fourth Amendment. And one of his famous speeches, it actually marks the birth of a phrase that we hear all the time in this context. And he said, now one of the most essential breaches of English liberty is the freedom of one's house. A man's house is his castle, and while he is quiet, he is as well guarded as a prince in his castle.
Yes, and y'all, we love the phrase that our home is our castle here in Texas.
All the time.
We even have something called castle doctrine, which is a little different than this.
Yeah, but it stems from this idea.
Yeah, it does.
And we'll get into this, but you have more expectation of privacy and more rights pertaining to the Fourth Amendment in your home than you do anywhere else. In
fact, you have a lot of privacy in your home, Fourth Amendment and otherwise.
Yeah, absolutely. And so I said this a second ago, but I want to make sure that I hit on this again, that the case law that the Supreme Court looks at, the cases they look at and the decisions they make, they're constantly counterbalancing two principles. One is the societal importance of law enforcement's goal of ferreting out criminal activity, discovering this activity, seizing evidence and all that, versus how much that law enforcement activity is actually intruding on someone's reasonable expectation of privacy. And that makes sense. We've got to encourage and give law enforcement the tools they need, but then we have to curtail that and make sure that everybody's privacy rights are protected.
Right. Yeah. So we want to be safe, but we don't want to be a police state.
Exactly. Exactly. And that spectrum is constantly shifting.
It is. It's constantly shifting as new technology is introduced, right? Because, look, John Hancock isn't going to be like, holla back, brah, I've got a smartphone. He doesn't even, they wrote with quills, for Pete's sake.
Yeah.
And now we have pens and mechanical pencils.
Right.
They never could have dreamed of the fact that we're walking around with small computers in our hands. They didn't even know what a computer was.
Yeah.
So how are they supposed to create law that effectively tells modern law enforcement how to respect the privacy of someone's phone, or how to respect the privacy of someone's home when they have security footage and cameras, outside their home or inside their home?
Yeah.
Or when they have a Google Nest listening to them, even though Google says it's supposed to be not listening unless you activate it. So, so on and so forth. So, like you said, as the Fourth Amendment is our constant, but technology is changing. There's constant case law that's asking for further interpretation of application to new technology.
Yeah. Yeah, and I think cell phones are the biggest area that we see this in. Because even if you're looking at, okay, whether you have to get a warrant for the cell phone, whether or not you can use cell tower locations to track where someone was or wasn't, all that types of stuff. And that's a little too detailed for us to get into today because it's constantly evolving case law. But it's impressive and interesting to see how the courts are applying a 300-year-old principle to modern day technology. And
I have to hand it to the founding fathers. I mean, again, there was wrote with quills, no way they could think of a smartphone. But the Fourth Amendment has been, the way it was written, has done incredibly well at applying to vastly developing or quickly developing technology.
Absolutely.
And so I find that really interesting.
So to jump right into analyzing the Fourth Amendment, I did think it was important that we define out some terms that are used constantly, because we're going to use them in our hypotheticals, and you hear them all the time. And so I'm just going to run through these, and we're oversimplifying a little bit.
Just a little.
But so the idea of a seizure, the other way to put that is being arrested. So you say unreasonable searches and seizures. A stop is when you, like a traffic stop, someone constrains someone's freedom of movement in a less significant way than arresting them. So the traffic stop is usually the best way that I think of that. A search, that's pretty self-explanatory. It's any kind of searching of one's person, of one's home, vehicle, anything like that.
Other than like a frisk or a pat down.
Right, which is different than like a frisk. So like how would you describe a frisk compared to a search?
I mean, you see it in the movies all the time, or if you go through the metal detector at the airport and say that you've got like a bionic knee or whatever, they have to like pat you down.
Right.
Or they'll wand you, but ignore the wanding part. So they'll just pat you down to make sure that they're not feeling any bulges that feel like it could reasonably be drugs or guns on your person. Right. So they're not going into your pockets, they're just patting you down, pat, 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 all like over on the exterior of your clothing. Right,
and that's going to become important when we talk about the different types of detainments here in a second. Probable cause, and this is one I want to pause on for a second, make sure we describe it accurately.
Super clutch.
It's a degree, and this is the actual technical term, it's a degree of evidence required to search with or without a warrant or to arrest somebody. And it's got to be that the known facts and circumstances are such that a person of reasonable caution would feel a fair degree of confidence that he knows what is going on is a criminal offense. And so probable cause is the standard we get to arrest somebody or to initiate a warrantless search on somebody's person. And so you've got to have enough facts that you've observed as a law enforcement officer and knowledge within your own head about certain things, which we'll get to in a second, sufficient to say, okay, it's reasonably likely that criminal activity is going on right here and that I can see that he or she actually committed a crime.
Yeah, so let's give an example, right? And you're gonna have to jump in because I don't know a lot about drug stuff.
Yeah.
So I'm gonna need your help on that one.
Not a drug guy, just defend them.
Yeah, you just defend them. So say you've got Jimmy of our former Adderall kingpin at State University.
Yeah, there you go.
Yeah, so Jimmy's gotten out of jail, after dragging poor sweet little Kimmy down with him. If you want to hear more about Jimmy and Kimmy, y'all go back to, what episode was it? 40?
You know what? I don't remember the numbers.
Okay.
I'm bad with the numbers on this thing.
Oh, I know. Okay. Anyway, it was around there. It was our episode on El Chapo's wife.
Yeah, it was federal sentencing episode. Yeah.
Federal sentencing episode. Anyway, so Jimmy is out of jail. He's driving his hybrid car because he's environmentally friendly with his man bun. And then he gets pulled over. And his car reeks of, does meth smell?
Let's go with marijuana. That's usually the easiest
we'll just
one.
go with marijuana. Yeah. Reeks of pot, like really bad. Like he's been hotboxing himself, y'all.
Yeah.
And then he's got, do people use pipes for marijuana?
Yeah.
Okay, so he's got a pipe in his frocket, so like his frat shirt front pocket. Anyway, so he's got that. His eyes are super blood red. And he's got little joints that have been like crushed out on his console.
Okay.
So I'm making it real bad for Jimmy.
Well, I was gonna say we're way past the point of probable cause at this point.
I know, but I'm just trying to be really ridiculous. So Officer Warren pulls up because Jimmy has just completely run through a stop sign and narrowly missed running over Tommy the kid. And so the officer pulls him over and he's like, looks in the car. He sees the pipe in the frocket. He sees the crushed joints in the car. And he asked, Jimmy, can I see your driver's license and registration? Jimmy rolls down the window and bam, hit with all of the pot smell. Jimmy looks over, pulls the sunglasses down, super red eyes. Is there probable cause?
Yeah, he's going to get arrested on the spot.
Yeah.
There's no need for a search warrant or any kind of further investigation. They'll send the marijuana off to a lab to get tested, but there's multiple offenses there. He blew through the stop sign. He's driving under the influence, or he's driving while intoxicated probably, and then he's also got the weed possession right there. So yeah, that's the arrest can be made on site at that point.
No warrant needed.
No warrant needed. Now, that's probable cause. You've got to see clear facts that a criminal offense has occurred or it's more likely than not to be occurring. Sure. Reasonable suspicion is a less extreme version of probable cause. It's the way I usually talk about it. And this is the degree of facts that you need to actually stop somebody and have a conversation with them and detain their freedom of movement, but not arrest them. And we're going to detail what that actually means. Sure. But the way that it's laid out by the courts it's been that you must have specific articulable facts and reasons identified by a law enforcement officer to justify the suspicion to stop somebody.
And we call this a Terry stop.
Call it a Terry stop because of Terry versus Ohio, which is where this concept of reasonable suspicion came from. And actually, I'll just tell you the Terry versus Ohio story, we're going to get into a hypothetical that's highly similar to that later and kind of illustrate how you draw this out and draw this distinction. And one thing we probably should have led with, when it comes to searching somebody or something or arresting somebody, you have warrantless searches and arrests, and you have searches and arrests that were sponsored or prescribed by a warrant.
So for those who don't understand what a warrant is, what actually is a warrant?
So a warrant, and this is a checks and balances thing here, which is, it's again, we kind of nerd out on this, but it is kind of beautiful the way it all fit together. Law enforcement is a part of the executive branch. To get a warrant, they have to go to a judge or a magistrate, which is another form of a judge in the judicial branch. And they have to say, here are the facts. I saw the weed in his shirt. I saw, they wouldn't do it in that situation. But here are the facts that I've observed. And these are the reasons I think these facts amount to violating this law. So
this particular specific law. You can't just say, I think he's doing something illegal. Right. It has to be specifically.
And you've got to identify, if it's a search warrant, you got to identify the place you're going to search or the person you're going to search. You got to identify what you're looking for. You got to put a scope on what that search is going to be. And in certain situations, it can be more broad, but the judges are really tasked with making that specific area and the breadth of the search be tailored to what facts have actually been confirmed and observed.
So for example, the warrant can't just say, we're going to search the house that Jimmy lives in because Jimmy lives with his parents and his parents are tech entrepreneurs and have a giant mansion.
Yeah.
But they could say, we're interested in searching Jimmy's room and then identify critical spots in the room that they want to search.
That's a great example. That's a fantastic example because they're narrowing it to the room because they think Jimmy's dealing and they have specific reasons to believe that. And so they're going to tailor the search to that. Judge is more likely to grant that warrant.
Yeah.
And then, they can't go outside the scope of that search either.
Because if they do go outside the scope of that search and then they find something, say that Jimmy's parents have been out of town for the week, and so Jimmy is feeling more lax, and he leaves his pipe thing lying on the kitchen counter. Well, that was outside the area to be searched, right?
Yeah. Well, plain view might get in there.
Okay.
But let's say he has in the drawer in the kitchen.
Yeah, it was in the drawer in the kitchen.
They start going through drawers in the kitchen. Well, okay, they've gone outside the bounds of the warrant. So if all procedural steps are taken right, anything they find outside the scope of that warrant is going to be excluded, and the judge is going to throw that evidence out.
So even though they found it and it's clearly relevant and Jimmy admits it's his, they can't use it.
Right. And there's some nuances to that, but generally that's the concept.
As a general rule, yes.
So we call it the exclusionary rule, or one of my favorite terms in law, the fruit of the poisonous tree. You can't violate the warrant, find fruit, and then use that to convict somebody.
It's rotten. There are worms in it.
Exactly. Great analogy. Great analogy. And I'll tell you too, just to break this down a little bit more, in most situations, if the officer can establish probable cause by his or her own observations, and they're allowed to actually bring in their training and experience. And we'll get into some examples
and canines.
of that. And canines.
That's my favorite part.
That's a great example. You know what? I'll add that into one of our hypotheticals here, just to have some fun with that.
Kenny the canine.
Yeah. Yeah. Have you ever, sorry, tangent, have you ever gotten to go and like observe the training of these dogs?
No, but I really want to, because when
fun.
we were on the height of lockdown, I watched so many police dog training videos on TikTok.
Yeah, it's fun.
It's incredible what these dogs can do.
100%.
I would like want to be best friends with these dogs.
Yeah.
Except that they could probably kill me.
It's scary what they can do too, but they're so highly trained. It's very impressive. So there's a lot of situations where you don't have to have a warrant.
Yeah.
You pull somebody over, you observe enough to say, okay, he's driving while intoxicated. I don't need to go get a warrant for that specific arrest.
Yeah.
There are certain places and situations where the Supreme Court has said you absolutely have to get a warrant to search a place.
Full stop, no exceptions.
Right, no exceptions at all. And that's typically on a what they call a public felony arrest. That's been grayed a little bit because drug possession.
What is a public felony arrest?
So it's really more of an old school term of, okay, if you're going to arrest somebody for a felony basically the idea is it used to be to arrest somebody for any type of felony, you had to have a warrant. Well, that's strayed now because with drug possession charges, with murder, all that kind of stuff. If you observe something on site, that's going to be an exception that's going to get you out of that.
So what's like you saw?
Well, so let's go with the drug. Let's go with the drug thing situation.
Okay.
If they've got cocaine, well, that's going to be a felony automatically. So really, if they observe that, they see the residue on the dash, they're able to say, okay, we know in our training experience, because I can rub it on my gums and see how it gets numb and feel it.
Wait, do they really do that?
That's a thing.
Wait, what?
It's not just in movies.
What?
That's a thing. If they can do that and test it, and they're like, okay, you know what, we can make this arrest on site.
Wait, this is wild. You put it on your gums?
We're gonna have to talk more about this later off camera, but yeah, that's how you can sometimes.
Wild.
That's a kind of a life hack way of determining whether or not it's real.
I won't
Not
be
just
using
a movies
that.
thing. So, but a home is one place where you have to get a warrant to search the home, absent some exceptions, which we'll get into later. And that goes back to the home is your castle kind of situation. Another situation that has developed, at least here in Texas, I'm sure it's this way across the country, but drawing someone's blood when they're being investigated for a DWI. Yeah. If they refuse, you do have to go get a search warrant for that because it's an intrusion into their body. And so
literally an intrusion into the most sanctified thing ever, which is a person's own body.
Right. So now I want to get into some hypotheticals because that's the best way to explain this. Yeah. And I'm going to sit here. I got to draw back to, I wrote in the outline that I got to explain to everybody what I call my Professor Lowy theory.
Your Professor Lowy?
He was our federal criminal procedure professor. And he had a really good point. And this is the same analogy I tell every time I'm trying to explain certain things to people. Every single time we read a case where someone's Fourth Amendment rights are being challenged, whether someone's saying my Fourth Amendment rights were violated by the police and therefore you should throw this conviction out. Well, every single time they did commit a crime. Like the only way that they get to the Supreme Court is that they were found guilty at the trial court level because the trial court said, no, your Fourth Amendment rights were not violated. They appeal that. Let's just take it in the federal system. They appeal it to the Fifth Circuit. Fifth Circuit says, well, no, we don't think that your Fourth Amendment rights are violated. Then they appeal it to the Supreme Court. And then the Supreme Court looks at it and says, well, you know what? Actually, we think that based on the way things are right now and the way the search was done, it was unconstitutional. It was a violation of your Fourth Amendment. So we send it back down to the trial court and say they have to remove that evidence. Usually that leads to someone being found not guilty or usually the case dismissed. And a lot of people, if you're analyzing that, it's hard to feel okay about the defendant who committed the crime getting off on that and wrapping your mind around, well, but he was trafficking drugs. He was doing this. She was whatever.
And I want to say too, and I hear this in My Favorite Murder or other criminal podcasts or documentaries where people are interviewed or Vanity Fair articles all the time. People get furious. They get so angry when, as these non-lawyers put it, oh, he got off on a technicality. I can't believe it. There's no justice. He got off on a technicality. That girl died because he dealt her drugs and he got off on a technicality. I can't believe that wasn't justice. Well, actually, it's really important that the rules are followed because the rules are what create the justice system in the United States. So your concept of justice, right, is probably stemming from a moral concept, which is completely different from the actual rules creating the justice system here in the United States. So they're very different, and I understand why people get upset. I would get upset too. I don't think, a college girl should be ODing on coke that a dealer gave her, right? That was wrong.
Right.
But if the DA or AUSA can't prove that up, they need to be held to their burden, because if they don't, then what's to say someone innocent who's accused is going to be, not going to be put behind bars because, the AUSA was like, oh, well, we think you did it, so justice should be served, but they were wrong. Right. And unless those rules are there to protect the innocent person from having their rights trampled on, justice wasn't served in that situation. So you need those rules in place to protect the innocent.
Yeah, and that's the banner I've been waving my entire career about this subject. And the situation I always talk about, because it's easy to draw two distinctions here. Say you've got a report that there is a black Escalade that's running drugs down I-45, and that they believe it's got a nice, sizable amount of dope that they're running. And
not ghost dope.
Not ghost dope, actual real dope. And then an officer acting on that assumption and not having any other corroboration, just sees a black Escalade, doesn't have a license plate number, doesn't have anything, pulls it over. Well, first hypothetical, let's say it's a soccer mom that's just driving around, and this officer is hell-bent on trying to find these drugs, so he asks her to get out of the car. He searches the car without her consent. He doesn't have a warrant. He doesn't see anything else that leads him to believe there's actual drugs in the car. He takes a knife, he cuts up the seats, because he's also heard that this one guy tends to sew the bricks into the seats of the car, destroys her vehicle, doesn't find anything, so she never gets charged with a crime. But
now what she's left with?
She's left with damage to her car that she under sovereign immunity principles may have no retribution for. She may not be able to get reimbursed. Maybe her insurance is going to cover that, but her rates are going to go up.
Yeah.
She was innocent.
Sovereign immunity is when you can't sue the government.
Right, which officer being an extension of the government. And we're not going to get into the analysis.
We got into that a little bit in a prior episode with the winter storm. So go listen to that one if you're interested in that, but we're not going to get into it here.
Right. And the idea is her individual liberties were infringed upon. Her Fourth Amendment right was infringed upon because this officer conducted an unlawful search and she was damaged by that. She may have no remedy. Now, because she was never charged with a crime, no court's going to analyze whether that was a lawful search or not, because that's not relevant. Yeah. It's only relevant in criminal cases. Juxtapose that with, okay, they actually do pull the drug runner over and they do the same thing, illegal search, because they didn't have probable cause. Tear up the vehicle, they find the cocaine. His lawyer files a motion to suppress, which is the tool you use to say Fourth Amendment rights were violated, so you should suppress this evidence. Judge says, yeah, you didn't have probable cause, you didn't have enough evidence, and you didn't go get a warrant, and this is an illegal search. Cocaine comes out, you can't use it at trial. Prosecutor says, well, okay, you're right, can't use it at trial, I'm going to dismiss the case. Well, the drug runner walks, and that's back to the situation we were just talking about. That's not what we want.
No, it's not what we want.
But you do that so that that's the way that you enforce the Fourth Amendment. And hopefully that officer, the next time around when the soccer mom gets pulled over, doesn't infringe upon her, the innocent person's individual liberties. But the only way we get to enforce those rules is if the people who actually commit the crimes, if we actually look at that and have the court come through and say, okay, that was an illegal search. Because otherwise, we've talked about this before, you can't have a hypothetical case before the court.
And I think that's really important too, especially in this day and age, to make sure that these rules are followed, because let's be real, is it going to be a white soccer mom that's being pulled over? Probably not.
Right.
It's probably going to be, a soccer mom who's a person of color.
Yeah.
And there could be some racial profiling going on there. And that's not okay.
And we've got a lot of mistrust of government right now on all ends of the aisle.
Yeah.
And so that's why it's even more important.
It's even more important that these rules are followed. So this soccer mom can be just as protected as her white counterpart.
Right. And so I say all that to say you've got to look at it in the mindset of, we know these people are guilty.
Yeah.
They committed the crimes, but we're doing this to protect the innocent. It's the reason we do all these things.
Especially if there's kids in the car, man.
For sure. So, traffic stop, that's the first hypothetical, and we're going to go a couple iterations in here. And so, facts that we're going to start off with, Miguel is driving his red convertible R8, really nice Audi, Tony Stark car. Iron Man car.
Okay, I know Iron Man.
And so he's going down Good Latimer in Deep Ellum at 1:30 a.m. on a Saturday morning. Kind of the tail end of a Friday night. Patrol officer for Dallas PD sees the car rolling down, down the street, and his gut tells him this guy's probably either drunk or he's probably dealing drugs. He's got a feeling. He's got a
vibe.
Yeah. And so he's gonna investigate. He's gonna follow the guy. He's gonna do all these things. Now, in a traffic stop situation, and a lot of people are probably familiar with this, but someone can't pull somebody over. A cop can't just pull somebody over just to pull them over.
Yeah, no, there has to be a reason.
There has to be a reason, and usually, I mean, breaking it into these parameters, you've got to have probable cause that they violated some traffic rule. Some traffic, rolled a stop sign, didn't use a blinker, and that's the situation we're going to use
Blasted
here.
through a red light.
Right. Well, and I forgot to say this part. So he's got to have a reason to stop Miguel. He can't just go off of, I've got a gut reaction, or this is a high-end sports car driving through this area where there's a lot of clubs, and so there's drug activity going on. There's a lot of drinking, probably drinking and driving. This guy's probably drunk. It's 1:30. It's not closing time yet, but we're getting close to it.
Yeah, it's close.
He can't pull somebody over just because of that. Now, what he can do, once he pulls them over, if he starts to see other signs of that type of activity, he can use that knowledge to help bolster his claim for probable cause. But he can't just pull him over just because of that.
Sure.
So let's say Miguel fails to use a blinker. At that point, can the officer pull him over? Fails to use a blinker, switches lanes.
If he's switching lanes erratically and fails to use a blinker, yes.
So actually, if he fails to use a blinker because traffic laws say that you have to use one, he can pull him over for something as simple as
that's
that.
interesting.
Yeah.
I didn't know that.
Yeah.
Okay, so I always use a blinker when I drive, and I get irritated when people don't. So I'm glad to know that I'm in the right.
Yeah, so failing to use a blinker can give the officer probable cause to pull him over.
Oh, well, look at that.
Yeah, and now you have to piecemeal this stuff, so once he pulls him over, it doesn't mean, okay, cool, I got him, I'm gonna search his vehicle, let's do this. It's not that.
Yeah.
He can pull him over, and then he can detain him and talk to him and write him a ticket if he wants to, write him a warning. He can also conduct a further investigation by just observing what he can see from the car, smell, so, the five senses, all those types of things. So let's say that upon approaching the window, officer says he smells a strong odor of alcohol and notices that Miguel is slurring his speech. At this point,
And does he have a stain on his hot pink shirt?
let's say not yet. Let's just say that let's just say he smells it. He's slurred speech. Let's say he's already written him the ticket.
Oh, okay.
Let's just say he's already done that. So the traffic investigation.
Can you get a
done.
ticket for not using your blinker?
Yeah, traffic violation. I mean, usually you're not probably going to get that, but yeah, you can. You can, and it can be, the beginning of a traffic
I'm
stop.
so glad I use a blinker.
So let's say he's already written the ticket. He smells the alcohol. He says that the officer that he notices Miguel is slurring his speech. At that point, can he keep Miguel there longer to investigate more?
I would think so.
Yes, he can. So that's reasonable suspicion right there that there's DWI, because he can specifically articulate, I smell alcohol. He is slurring his speech, and he's driving a vehicle. I just observed him driving a vehicle, and if he's doing that, and those are signs that I know in my training experience tend to show someone is intoxicated, well, I can keep him here longer. Can't arrest him yet, because I haven't gotten probable cause yet, but I can keep him there longer. I can ask him to get out of the vehicle. Now, here's something I learned in law school that I didn't like, surprised me though, but everybody should know. If you have been stopped by an officer, even if it's just for a traffic stop investigation, the officer is legally allowed to ask you to get out of the car, and you do have to comply.
I forgot about that.
It's been held that it's not a Fourth Amendment violation because it's a safety concern for the officer. He wants to be able to see, he or she wants to be able to make sure there's no weapons within reach and all that kind of stuff.
Yeah, that you're not going to pull a taser on him.
Right. Or, gun between the seat, all that kind of stuff.
That too.
So it makes sense to me. I don't totally like it because it can be used as somewhat of an harassing technique too, because then they can also frisk you while you're out of the car too. But just so our listeners know, if you're asked to get out of the vehicle as a traffic stop, you do have to get out of the vehicle. So, like we said, he can continue his investigation, and typically what happens in like a DWI stop, which is what we're kind of simulating here, is they smell the alcohol, they say that there's slurred speech, they notice the eyes, and then they ask you to get out of the vehicle.
The eyes are red and unfocused?
Right. And then the field sobriety test, which we talked about on our DWI episode, that's another further investigation that's allowed to be done under reasonable suspicion. And then the officer uses that to develop his probable cause that says, okay, you failed the test, therefore I have enough warrantless, I can arrest you. But let's take it out of the DWI context.
Okay.
Let's say he pulls him over, same deal, failed to use a blinker. Miguel is wearing white pants, and a silk shirt that screams that he's straight out of Miami Vice.
I mean, that's a pretty cool show.
It's a cool show, total party animal. He's driving away from these clubs. He's blasting EDM out of the speakers. Officer thinks that everything about this guy screams that he's definitely selling coke, just left bottle blonde. He's absolutely in there dealing drugs. Like this is everything he can see about this guy screams that.
Drug kingpin is back.
So he can ask him to get out of the car, but on that information alone, do you think he has enough to actually search the car for drugs?
No.
Okay.
There's not a smell. There's no erratic activity. There's nothing to indicate that he's been snorting coke or dealing.
Right. And so that's the situation that, in that circumstance, if he searches the car and finds something, he didn't have probable cause to do that, didn't have a warrant, probably going to get thrown out, and Miguel's going to end up walking free.
Yeah. So he'll be fine.
So let's go to a second hypothetical. Let's call this the street walking hypothetical.
The street walking.
And this is one that I
You might want to rephrase that because that makes me think of a Pretty Woman situation.
Well, I mean, it could apply there too. Prostitution is a criminal offense.
In Texas.
And so I based this one off of the Terry versus Ohio, the Terry stop that we talked about earlier. It's very similar. So say Patrick is walking down Main Street, Dallas, 9:30 p.m. on a Wednesday. Patrol officer has seen him walk up and down the same 4-block stretch from Field to St. Paul Street.
Oh, so maybe he is a Pretty Woman.
Maybe.
Yeah.
But he's seen him do it at least 5 times over the course of the last hour and a half. And Patrick keeps stopping at certain storefronts and kind of peering in, looking around, and walking away. And then he'll come back.
Sketch.
And so he's, in the Terry versus Ohio case, this is similar to what happened. And the officer testified that it looked like Terry in the situation was casing the joint.
Casing the joint, like looking in to see, let me identify how I could break in and steal the product within the store.
And that's what the officer was thinking. And so the officer in that situation, and let's say that here, in our hypothetical, this specific officer knows that some of the shops around this area, they've been robbed here in the last 6 months, and so he's kind of on high alert about some of this activity. So the question is, after observing this, can the officer stop Patrick and conduct a further investigation based on these facts alone of what he's observed?
Well, this goes into a casual encounter versus a Terry stop, doesn't it?
It does. It does. Well, so what is a casual encounter in your words?
In my words, shoot, you're making me think all the way back to crim law. Woo! So, I mean, look, right? If you see someone walking down the street and they're acting sketchy, but there's nothing that is screaming criminal behavior, or there's nothing on them that makes you actually have reasonable suspicion that they might be engaging in criminal activity, I don't think you can stop them on the street.
Yeah.
Now, however, if someone is, I don't know, let's make Patrick a girl, Patricia, right? She's in a really short skirt and a really, I'm probably going to get in trouble for describing basically what probably sounds like a hooker's outfit, right? But she's walking in an area that is known to have women who are trying to solicit business for prostitution, and say that she's stopped a few men and only men in cars and talked to them, and then she's jumped in a car, came back out half an hour later, and she's stuffing some dollar bills in her purse. Well, I think that would be enough, wouldn't you think?
It'd be enough to stop somebody based on reasonable suspicion to have a conversation
about them, on the crime that the officer believes that Patricia was committing prostitution.
Right. And the difference between a casual encounter and a reasonable, casual encounter, an officer can walk by you on the street and say something and you don't have to say anything back. You can be rude, do whatever you want to do.
Don't be rude.
But don't be rude. But if it's a casual encounter, then it doesn't matter. They can't do anything about it. A reasonable suspicion means they actually are stopping you and not allowing you to leave just yet. You're not under arrest, and there's a limit to what they can do and not do, but they are allowed to stop and talk to you. And that's the situation we have right now with Patrick, and what we had with Terry versus Ohio is the officers observed enough suspicious activity that he can specifically articulate and say, this looks like criminal activity.
Sure.
He can stop Patrick. He can't search him. He can't detain him.
Can he frisk him?
He can frisk him if he's worried about his safety.
Okay. Now, if he's worried about his safety, so there has to be something to trigger the officer's worry about his safety.
And it's very subjective. It's very subjective.
Of course it is.
And so he's allowed to stop him, and he's allowed to frisk him for weapons. He's allowed to continue his investigation. Sure. So let's talk about the frisk real quick, because I've got a case here I listed that's, to me, it drew a great distinction. It's Minnesota versus Dickerson, Supreme Court, 1993. The frisk maneuver that was established which you can do on a reasonable, if you stop somebody based on.
So long as there's reasonable suspicion.
Reasonable suspicion, not a casual encounter, but reasonable suspicion. Officer is allowed to frisk for weapons only.
But not drugs.
Not drugs. And do it, it's for the officer's safety. So the officer can pat the person down, make sure, and if he feels a gun, something that's hard, heavy metal object, he's then allowed to search the person because it may be a weapon.
Or a knife.
Or a knife, yes, any kind of weapon. Now, Minnesota versus Dickerson, guy was stopped, guy was frisked. He thought the guy had drugs on him, but he was frisking for a gun. He's doing what he's allowed to do. The officer was. What he felt in the guy's jacket pocket was what ended up being a couple of gumballs in a wrapper.
Well, right, so he could have gone to the arcade and just gotten some gumballs from a gumball machine.
Right. Well, he felt it, and then he squeezed on the wrapping, and he felt it. He thought, okay, well, this feels like drugs. So then he searched the rest of his person. He found drugs on him in another area that were like stuffed in his shoe or something like that. Dickerson was charged, appealed his case, said that was an unreasonable Terry frisk. That's what we call it. What the Supreme Court said. And this is like the moment in law school I was like, you can really draw that. Okay, you can draw that distinction. I'm cool with that. So the Supreme Court said that the frisk was lawful. When they touched the gumball on his jacket, that was legal. The unreasonable search was when he squeezed. That was an unreasonable search. Gumball. That was an unreasonable search because it went beyond the bounds. Well, no, it is funny.
It's funny because it's highlighting, right, such a serious concern what the difference is between reasonable and unreasonable search of the person.
Yeah, I do think it's fitting and probably appropriate and maybe it should make people feel a little bit better is that he did that, squeezed it, and then he searched his entire person. All he found was gumballs. That's what led to the entire search. Nothing, no contraband, nothing. It was gumballs in a wrapper. So an officer in that, the moral of that story is the officer can frisk you, but if he feels something that maybe feels like drugs or something like that and he squeezes it, well, okay, now he's violated the Fourth Amendment. And so then we've got the exclusionary rule that kicks in. So drawing distinctions that are really important.
The gumballs.
The gumball distinction. The last caveat I want to throw on this, and we could talk for a long time about the corroborating witness idea. This is like CIs and undercover officers, all that kind of stuff.
Confidential informant is CI.
Yeah, thank you. Or anonymous callers that call in and tip the police off.
Which is wild.
Which part?
That you can have an anonymous caller tip in to the police.
I don't know that they're as anonymous as they maybe used to be, because I'm sure they're going to want them as a witness. Yeah. But the Supreme Court has said that if an officer has been given information from an informant or a witness that they then can corroborate about a certain situation they're observing, then at that point that may lead to reasonable suspicion enough to detain the person, and in some cases could be probable cause depending on what else they observe. And so example would be, let's say that, let's go back to Patrick.
Sure.
Someone says, they call in and they're like, there's a guy, I've been talking to him, I know that he's going to try to rob, I don't think it's open anymore, but the Neiman Marcus that was on Main Street. He's going to try to break in and rob Neiman Marcus. And he's going to be wearing a green hoodie. And then...
A green hoodie.
And let's make it even more specific. It's going to be after 6:30 p.m.
And it's a neon green hoodie.
Let's go St. Patrick's like forest green.
Okay, sure.
But see, at that point, though, he's got a guy walking up and down the street outside of Neiman's wearing a green hoodie after 6:30 p.m. on this specific date. Okay, he's definitely got enough right there to stop him and detain him and talk to him. Now, I mean, as I just described,
does he have enough to frisk him?
He does. He does. And then if he finds a weapon on him, then all of a sudden we're into the probable cause arena, and now he gets to stop and investigate even more and maybe arrest him at that point, because it could be unlawful, unauthorized use of a weapon. As you can imagine, because I just listed off, okay, he said green hoodie this time. The way that the court parses that out and how they decide what's enough corroborating information and what's not, there's been many, many cases that dive into how detailed it has to be. And there's no black and white. There's black and white in certain situations. But just suffice it to know that a corroborating, thank you, witness
I'm here to help anytime, Austin.
I get excited and start talking fast.
I know, I thought English was your first language.
It is. You can use a witness that calls in with information to help justify your Terry stop and conduct your further investigation. Last thing we'll talk about is the I call it home invasion. Home is your castle. Warrants required unless there exists some type of exception. And the thing is that it makes sense that the judge is going to have to look over this and make a decision before the cops can go in. And so if you've got, and I'm going to abbreviate this example, but this happens a lot with trap houses, drug houses where they're dealing out of.
Trap houses, like
slang term for it.
Okay. I was like, hold on, I've heard this in like rap.
Yeah, and that's what they're talking about.
Gotcha.
Trap house is a stash house. That's where they're using, they're either dealing out of one, they're stashing in the other.
It makes so much more sense now.
And so that's a lot of times you've got officers that are, staking out the property, trying to observe things, whether it's people coming in and out, whether it's something they can see in plain view through the windows, all sorts of stuff like that, because they really are trying to build a case so they can get a search warrant, and so they can execute that search warrant and go in the house. And they've got to get, because they're not going to be able to get a plain view in the home, they've got to do things like get a confidential informant. They've got to really stake it out and see a lot of activity that they can point to, potentially criminal activity. They've got to arrest a couple people that leave the house that have drugs on their person. And so it's a big deal because it takes so much to get into that house.
And I want to bring in the example of the canine unit here, because I think that this is where canine units, you can see the classic example, right? So you can walk the dog up to the house, right? And you can even, walk the dog up to the front door if there's a clear pathway, correct?
Yes, and there's some law on the curtilage of the house.
There's some law on the curtilage. And
curtilage is like the front porch, the front yard.
Yeah, it's the immediate area that's outdoors but surrounding the house, the curtilage. So say that there's, let's just make it easy. Say that you walk the dog, you're on the street, and the dog is already sniffing and it's alerting, from the street, right? Because there's not very much curtilage, right? There's like maybe a foot of curtilage between the front door and the public street.
Yeah.
The dog is already alerting, it's sniffing. It does the alert, it sits down, paws up, which actually for the longest time, I literally thought, according to my criminal law professor, that the German Shepherd, which is usually what is used as drug sniffing dog, would literally sit down and put its paws up in the air to indicate that it had identified drugs. Didn't realize until probably after law school, that's not literally how it happened. But anyway, so the dog, the canine will signal to its handler that it smells drugs.
Right.
And the Supreme Court, and now they can walk up to the door, and the dog, the dog sniffs under the door, and the dog will alert again. And that, because people will say, well, isn't that an invasion of my privacy because a human can't smell it? No, it's not, because the dog can smell it, and you're still outside the home. You were even outside of the curtilage of the home in this situation. And that's that's evidence that I have not really seen overturned. Yeah.
Now it's harder with the home because you got to get past some of those things like the curtilage and things like that.
But in our example, the dog smells it outside of the curtilage.
Yeah.
And is clearly alerting.
Yeah, and as long as there wasn't anything violated up to that. Too, you see it more often with cars, right? Sure. They stop somebody and they're like, all right, well, we're going to get the canines. And actually, I just thought of this now, but the second verse in Jay-Z's song 99 Problems, actually a pretty good analysis of the Fourth Amendment.
Oh, really?
Yeah, actually there was a law review article written back when I was in law school from a school up in New York.
Verse?
Well, I'm not going to sing, I'm going to rap the whole thing, but
he
basically goes through an entire traffic stop.
Oh, does he really?
And the officer, he's playing like he's the officer and, all this kind of stuff. And then at the very end, the officer is like, okay, well, we'll see how smart you are when the canine comes. Because you can, as long as you're detaining someone legally, you can wait, have the drug dog come, and if the drug dog signals, then you can search the vehicle at that point.
So what if, for example, I used to go down to this, it's called Whidbey Island, it's off the coast of Seattle as a kid, and so we'd be in the ferry line, and there have been terrorist activities in some of the ports in Washington, so there were always, when I was going, there were always dogs and then the long mirrors on sticks that people would look, the officers would look under the cars to make sure that there wasn't a bomb on the car, and they would have dogs sniffing. So let's say, for example, that you have Kenny the canine, and he is doing the routine sniff of all the cars, and then he sits and alerts out front of a Tesla. What happens?
Tesla's going to get searched. And so it's kind of like at the U.S.-Mexican border. There's certain areas, like, for example, going into that island, and there's been terrorist attacks and fears. Certain areas, the government has said, okay, well, or the courts have said, we recognize that you have a lesser expectation of privacy because of the heightened danger that's present in those situations.
So if you're in like a border town or border crossing near Juarez.
Yeah, and the dog alerts, your car's getting searched. They're going to look. Now, they can't tear the thing apart, but they can look in the trunk. They can look in certain areas, things like that. And that goes back to that initial principle we talked about, the balance of law enforcement's ability to enforce and societal's expectation of privacy, or society's expectation of privacy. You have less of an expectation of privacy when you're getting on an airplane, when you're crossing the border, when you're going to a public place where there's lots of people and the danger of some type of violent activity is higher. The courts have recognized that, and it makes sense.
Yeah, it does.
Overall. So I know we went through a whole lot with the Fourth Amendment, but as you can tell, and as our listeners, as y'all can be able to tell, I mean, it's very expansive what all the courts look at with all of this. And I think my biggest takeaway from everybody with this is understand that it's there to protect innocent people, but the only way that we can do that is by analyzing it with people who actually committed the crimes. You got to wrap your mind around that to be able to understand why it is that it's not a technicality that people get off on.
It's the law.
It's the law. It's their protection of their individual rights. So get a warrant.
Get a warrant.
Go listen to Jay-Z's 99 Problems.
Don't mess with the canine unit.
Thank you guys for listening once again. Stay tuned for closing arguments. We've got an update on the final chapter of the Forest Park medical fraud federal criminal investigation case that just wrapped up here in Dallas.
Hey y'all, don't go. We have closing arguments coming up for you in just a second. But before you listen, make sure to rate, review, and subscribe to the podcast if you got any value from today's episode. And please share the podcast with others. And if you want to interact with Austin or me, or tell us what you want to hear next, you can find me on Instagram at andrea.s.turner, Austin at the Dallas Lawyer spelled out, or the podcast #lawyered spelled out. Look forward to hearing from you.
The Forest Park medical scandal has finally come to a close, with the kingpin Alan Beauchamp being sentenced to 5 years and 3 months in federal prison. Beauchamp, former CEO of Forest Park Surgery Center, was one of 21 defendants, including 8 doctors, who was indicted in 2016. This case involved over $40 million exchanged in an elaborate system of bribes and kickbacks paid by Forest Park to a statewide network of surgeons, workers' compensation consultants, nurses, chiropractors, and others in exchange for referring well-insured patients to the hospital so they could make more money. The stiff sentences sent down from the Northern District Court here in Dallas convey the U.S. Attorney's Office message. Patient needs, not physician finances, should dictate where, when, and how patients are treated.